Good morning and afternoon, everyone. Thanks for joining us for today's webinar on family dynamics in estate litigation, managing and avoiding conflicts, expectations, and perceived entitlements. This is the first webinar in our fourth annual estate litigation series. My name is Vivian Ho. I am an associate in the Trust, Wills, Estates, and Charities group at Fasken's Vancouver office, with a primary focus on estate and trust litigation. Before I introduce our speakers, please see the information slide that is on your screen. I would like to draw your attention to the survey piece. We value your feedback on our series and encourage you to fill in the survey before you log out of the webinar today. We are also continuing our automatic CPD certification process. At the end of the presentation, information will be shared and you can obtain your Ontario or Quebec certificate today. For our BC viewers, the Law Society of BC language will be added to the chat. It is my pleasure to introduce cross-country colleagues. Alex Kotkas is a partner and senior litigator at Fasken's Calgary office. He has appeared as litigation and arbitration counsel and has been an advocate before various statutory boards and tribunals. He provides practical advice and outstanding advocacy in high-stakes arbitration and litigation. He is also the founder and former leader of the firm's litigation and dispute resolution group in Calgary. Yoni Feingold is a partner in our litigation and dispute resolution at the Montreal office. His practice is centered on the resolution of disputes concerning wills, trusts, estate, and general commercial matters. He is regularly called upon to represent clients, including heirs, liquidators, and trustees, as well as local and international companies and their shareholders, officers, directors before the Supreme Court and the Court of Appeal in various complex matters. Now on to our presentation. One of the words in the title of this webinar is entitlement. Entitlement refers to the belief that one is owed benefits such as wealth or status without having to work for them. When there is an unexpected death in the family, some members may feel entitled to a share of the deceased estate or have expectations not properly reflected in the deceased estate planning. Today, we will address the issues that can arise in blended family situations, which often add complexity to common estate litigation challenges. We will also briefly discuss wills variation in BC and cases where there are children of the testator who are unknown to the rest of the family. We will examine examples and various safeguards, practices, and planning strategies that may help reduce the likelihood of an estate dispute. Additionally, we will also highlight pitfalls associated with common planning techniques, such as spousal trust, powers of attorney, joint bank accounts, and real estate held in joint title when family dynamics are not considered. Now I will turn it over to Alex for a brief overview of blended family situations before we introduce our first example.
Thank you, Vivian. Well, I'm sure that all of you attending are familiar with the scenario of blended families and some of the complexity that they can bring to estate planning. And there certainly are a number of issues that can arise as a result of blended families, which are, of course, very common these days. There are legal and moral obligations that are owed in blended family situations, or that are felt to be owed. And certainly a number of hopes, expectations, even resentments and suspicions that can arise amongst the biological children, the current spouse, and any stepchildren. And these types of emotions can often lead to conflict. And it's understandable. You have the biological children who have certain expectations in terms of the way they saw their lives proceeding and perhaps their parents' wealth to be passed down. and then a new spouse comes into the picture, and sometimes also brings children with them that become part of the family, and that leads to different outcomes, and it's difficult to adjust expectations. And so extra care, planning, and forethought is required by the testator and their advisors to minimize or avoid the risk of disputes and litigation arising in these circumstances. So with that, we'll move on to our first example, and I'll pass the torch over to Yoni to describe that.
Thank you, Alex, and thank you, Vivian, as well for the introduction, and thank you all for joining us today. Just an additional note on the profiles of the blended families that we're going to be discussing. We're, of course, sensitive to and appreciate the fact that demographics are changing, and the face and nature of the blends that make up the blended families are evolving as well. For the purposes of our discussion today, we've really focused on classic types of blended families. Some may call it old school types of blended families that are still relevant today and are still generating lots of conflict and lots of litigation. So in the next few examples that we will be looking at, we will consider a profile that everyone is really quite familiar with, which involves the second spouse. Additional parts of this profile would include that dad, and again, I say dad, not because we're projecting this into the world, but because it's really what we see in our experiences most often the case, and most often the dynamics that result in conflict. So dad remarries either after divorce or the death of mom. He's well-to-do, and he lives a lavish lifestyle, and he brings the new spouse and benefits the new spouse who enjoys this lavish lifestyle with him. And there are real tensions and discord between the children and the new spouse, either from the get-go or as the relationship evolves. So that's the type of profile I'm going to look at in this example, and which will be carried forward into some of the others. So the first example, as you can see on the slide, is one where dad decides to disinherit his child and leaves everything in a will to the new spouse. Obviously, you might say he's begging for trouble doing such a thing, but the question is, what if dad has a good reason to do so? What if, for instance, the child was already financially secured or well off? And what if the spouse, the second spouse, who's married to father for many years, was extremely dedicated to the relationship, was a tremendous partner, and helped dad through difficult times? Notwithstanding that, we find that you're still begging for trouble. And the rule that I follow is, good intentions plus inadequate planning results in trouble. So I'd like to discuss one case in particular that we were involved in. And again, just a note on the cases. Whatever we discuss here has already been part of the public record. We're not going to be sharing any names or details. Some of the facts have been changed. So bearing that in mind, I'd like you guys to consider the following set of facts. Mom and dad married for several years, had a child, and divorced when the child was an adolescent. Mom comes from a very wealthy family, that family was accustomed to paying for much of the daughter's life, and even set up a trust that benefited the daughter. Several years after the divorce, dad meets another woman, and they're married. There's a difficult relationship between the new spouse and the daughter, almost from the get-go. And naturally, that tension or that discord affects the relationship between dad and daughter. It's almost inevitable. In the case I want you to consider, dad, he gets sick. He's actually quite ill. He has cancer, and the new spouse gives up her career and much of her independence to care for dad for many years. It's not a short illness. It's many years, and she's highly devoted and caring. A few years prior to dad's death, and while he's in remission but still ill, suffering from his illness, dad prepares a will whereby he leaves everything to the spouse and essentially disinherits his daughter. When dad ultimately dies and daughter learns of the will, she was not aware of the details in advance. She takes an action. She sues the estate, sues the spouse, seeking to invalidate the will on the basis of incapacity and subsidiarily on the basis of undue influence. So the judge hearing the matter had an easy enough time dismissing the incapacity claim because the medical record was sufficiently complete and showed that dad, although he was ill and suffering from serious illness, at the time that he prepared the will, had all of the cognitive capacity necessary to testate. The bulk of the case, the bulk of the trial turned on evidence supporting and contesting the notion of undue influence. Just to bring some law into it, I'll read from the judgment how the court discusses undue influence. So I'm quoting here. There is nothing improper or illicit in attempting to influence a person in the making of their will. However, when it is established that the testator was subject to undue influence, the will can be annulled. Undue influence, which has been likened to fraud, can be found in lies, slander, deceit, trickery, or deliberate misrepresentations, which cause the testator to make decisions regarding their will that they would not otherwise have made. With respect to the proof, the court says such proof will most often be made by presumption, since the person exerting undue influence will rarely do so in the open, and the person being influenced can obviously not testify. So these undue influence cases, although they rarely succeed, they become a difficult trial in the sense that there is a lot of evidence that is going to be adduced. You're going to have testimony on both sides. One side, supporting the child's position that the spouse unduly influenced dad. The other side confirming how wonderful the spouse was and how difficult the child was. You're going to have documentary evidence. It's going to be rather complex and complicated for the judge. And really, you end up finding yourself in a situation where you're, to some extent, at the mercy of how the judge perceives or approaches the evidence. Is the judge looking for evidence explaining why the spouse received what she received, and did she deserve it? Or is the judge going to focus on finding evidence to explain why the daughter may have been disinherited? In the case at bar, I'll share with you a passage that I think tells us everything we need to know about how the judge actually considered the facts and the evidence. And I quote, "It is surprising, but certainly not unheard of, to see a father exclude his only child from his will. For such a thing to happen, one would expect to see evidence of major confrontations and blow-ups between the two, or out of the ordinary acts of cruelty or dishonesty on the part of the son or daughter, or some other behavior that would justify such a strong renunciation of the normal parent-child bond. So you could see from this passage alone that the court has taken a very clear position on what they consider to be normal or not, and how the evidence will ultimately be appreciated by the court. So how do we avoid a situation like that? let me just change the slide, get to our solutions. This, again, best intentions. The road to hell is paved in best intentions. The number one thing you can do if you find yourself preparing a will or advising someone who intends to prepare a will that is, unusual in the sense that a daughter or child is going to be disinherited or treated differently, is prepare a detailed letter of wishes or encourage the testator to prepare a detailed letter of wishes. This letter does not need to be shared in advance. It can be revealed and shared at the time that the will is shared, but it will explain in some greater detail the reason why dad or mom, the testator, decided to benefit one individual and not another. The father could easily have done so in our case, could have prepared a letter saying, look, my daughter, I love you. I mean nothing by the fact that I'm leaving everything to my spouse. It does not reflect my feelings for you. I know that you are taken care of financially, and my spouse took such great care of me. She has given up her career, and I want her to benefit. There would not have been a trial if there had been that letter of wishes in this case, and hundreds of thousands of dollars of fees and many years would have been saved. The other potential solution is, of course, and I recommend this frequently, is get a contemporaneous cognitive assessment done. If you're preparing in a will during a period of illness, or if you are elderly or otherwise frail, and you suspect that the document you're preparing may result in discord down the road, protect the estate. So I was going to say protect yourself. You're not going to be around. Protect your estate. Have a contemporaneous cognitive assessment done so that there is absolutely no doubt as to your capacity at the time to prepare that document. And I think in this case, those two solutions would have saved everybody a lot of time and money and heartache.
Thank you, Yoni. I'm going to address the next example, still within the blended family scenario. And here, what we're going to discuss is a common planning tool that is used frequently and often recommended by the accounting or tax advisors of the testator, namely a spousal trust. Now, spousal trusts are, a vehicle that is that is available and endorsed under the Income Tax Act, which allows a testator who is perhaps in a blended, typically in a blended family situation, but also in an original family situation, to benefit their spouse with the lifetime income entitlement to the assets of the estate, but also ensure that their children will benefit from the remainder of the assets, the capital assets, or the bulk of the capital at the end of their spouse's life. And so it seems, with the on its face to be like a useful and tax efficient planning tool. And it can be, but there are dangers inherent in a spousal trust, namely that you set up an inherent conflict when you create a spousal trust between the children who are the capital beneficiaries and will be looking to hopefully inherit, hopefully in their minds inherit significant assets. And yet you have the surviving spouse. It may be their parent, or it may be a second or subsequent spouse who is to be supported for their lifetime and to enjoy the income from the assets. And so, there are many different scenarios in terms of what the asset makeup may look like. But often it is possible in a spousal trust for the children, who are often trustees under the spousal trust, to deal with the income that flows from the assets in a way that reduces the amount available to the surviving spouse. And this is something that I have seen frequently, and that has resulted in costly estate litigation on more than one occasion in my practice. And often in the scenario of second or subsequent spouses, where the children from the first marriage are, they may be friendly with the subsequent spouse, but they are not necessarily feeling completely magnanimous towards that person. And that relationship, of course, typically does not improve once the testator has passed. And often there is less contact with that subsequent spouse, and the relationship can deteriorate, and again, inherent conflict will often create disputes. And so in the cases that I have seen, there is often not a steady flow or stream of income from the assets. There may be an operating company involved, in which case the income will be variable. When you have an operating company scenario, there are revenues, but the revenues don't necessarily translate into income because there are expenses of the business, and those expenses, frankly, are subject to some manipulation by those operating the business, often the children. And by that, I mean, businesses have expenses. They need to upgrade their equipment. They need to invest in growth and so forth. And all of these things sound like good business decisions, but often they appear to be, or are suspicious to be, a mechanism to reduce the income available to the second spouse or subsequent spouse, and increase the capital, build the business so that there will be more available for the children once that spouse passes away. And so this is something that can create disputes. And of course, the second spouse is thinking, expecting to be taken care of in the lifestyle that they enjoyed while their spouse was alive, and probably been assured that would be the case. And often that is not the case after the testator has passed. And of course, this creates a great unpleasantness, for all of the parties after the testator has passed. You have now these people fighting, they're at each other's throats, accusations are flying. And what is really, I think, practically a concern, aside from all of the legal cost and the uncertainty of the outcomes, I really don't think that the testator, for those of us professional advisors, our clients, mean for this to be the outcome. They don't want that for their family members, and so they've created a problem that they would very much regret. Some solutions are available. First of all, I think a lot of thought has to be put into the use of spousal trusts. I acknowledge they have a tax advantage in some circumstances. There are other tax planning tools that can be used. And the danger that arises in spousal trusts really needs to be weighed against that tax advantage. Litigation is very, very much a possibility, and alternative planning options, either outright gifts, creating an annuity, or other options, perhaps an alter ego trust, could be useful. So if, however, the tax advantages and the structure that we're being asked to do is a spousal trust, then my recommendation would be to use that only where there is assets that can be or are already invested in something with a clearly defined income stream, so that it's quite clear to all parties what income the spouse is to receive. And of course, there is the ability to encroach on capital in a spousal trust as well, but typically it's the income stream that is going to be looked to first, and that's what the spouse's initial entitlement is under the spousal trust. So that can work if there is a defined income stream. And those are our recommendations there. So now over to Yoni with our third example.
Thanks, Alex. I'm going to go right back to your solutions, having thought of something as well. Again, if you're going to use a spousal trust for valid reasons, all of the reasons for which they exist, you might also want to think hard about who to appoint as a trustee. You don't absolutely need to leave the capital beneficiaries as trustees to work with someone else on it. You can put everything in the hands of an independent professional trustee. There are lots of trust companies out there who can do a very fine job, which gives you and everyone involved, the benefit of believing in the impartiality of their decisions and the way that they manage. And another, at least in Quebec, when one thinks about financing litigation, if the parties don't have access to the coffers, they might think twice before taking an action or administering assets in a way that would, prompt someone else to take an action. So yes, think about who you want to appoint as a trustee. So the third example that we're going to discuss, this one kind of has it all. There's a second spouse, there's an ill-conceived power of attorney, there's discord between the children, and it's not just the children and the spouse, but it's the children among themselves. So this is a real blend with various documents that create problems. So consider the following facts. Okay, mom has passed away after many years of marriage. Dad is extremely wealthy. He need not be extremely wealthy. He could simply be well-to-do. And he's generous with his adult children, but they still have to wait to inherit. At an advanced age, Dad starts a new relationship with a new woman. In a case that I'm thinking of, the woman is herself a widow, has her own adult children. The relationship evolves quickly, and they move in together. The daughters are very much against this relationship. At first, it starts off as suspicion, and then it becomes a real antagonism. And in this case in particular, son is neutral, but he is also dependent on dad. So in the eventual conflict, son will split with his sisters and side with dad, and we'll see how that ends up impacting the conflict or exacerbating a conflict after dad passes away. So in this context, dad prepares two documents. He has one power of attorney, in which he names his daughters as his attorneys. And he also prepares a will, in which he bequeaths the condo and some registered account to his second spouse. Following the preparation of those documents, a year or two later, dad has a heart attack and he's hospitalized. He's not fully debilitated, but he's an older man and he's in hospital. His stay in hospital is extended. The daughters, who have a difficult relationship with the new spouse, they jump into action and activate the POA or attempt to activate the POA. And of course, the first thing they do is try to take control of all of Dad's affairs and all of his assets, including the condo that was to be gifted to the spouse under the will. Now, in this case in particular, Dad survives, but he spends the rest of his life, which ends, is 3 more years of living in constant conflict with his daughters. He manages to protect the condo, keep the condo within his patrimony, but there are lawyers involved, and he's wrestling control of his affairs and really his own independence, whether he is able to go on trips with his spouse, whether he needs to be assessed and just go on living a normal life. So he spends the remainder of his life fighting with his daughters. One thing he does not do, and that becomes an issue after his death, is he does not change his will. The question is whether he did that deliberately or whether he simply did not have an opportunity. And at death, the will that he had prepared comes into effect. There is no question about its invalidity. Dad had perfect capacity to prepare it. But son and the second spouse then team up against the daughters, and they take an action which may be unique to Quebec. We call it an action to declare certain heirs unworthy of inheriting as a result of their reprehensible conduct. So son claimed the daughters, putting the father through hell in the last few years of his life was so reprehensible that the court should declare them unworthy of inheriting. He should get their 2/3 of the estate. The daughters, in response to that action, claimed, first of all, that what they did was out of concern for their father, naturally, but also claimed that since Dad did not actually change his will and he knew of the cause of the unworthiness, he tacitly accepted it. But the bottom line is that Dad, who clearly cared for his daughters, who had a difficult relationship with son, had prepared 2 documents that in which there were no checks and balances, and it resulted in litigation and conflict during his lifetime, and then litigation and conflict after his lifetime. And for, I believe it was 7 years after his death, the estate was entirely frozen. And we're talking about significant sums of money that were basically or very conservatively invested, making absolutely no money. So let's look at some potential solutions. First, make sure that your estate planning professional understands the dynamics. Okay, here you have someone preparing 2 different documents. You have gifts that you actually want to benefit your spouse for whatever reason, but that's what you want, and yet you create a power of attorney which empowers someone who may be in conflict with that spouse, who would be given authority to act on that property, alienate the property, sell it, do what they need to do with it. So make sure that the person who is planning understands the dynamics, which requires, I suppose, some self-reflection. Discuss and integrate guardrails or checks and balances. So, for instance, put a limit on the scope of the POA. If you want certain assets to be secured, secure them, and state that, okay, my daughters who are going to be the administrators or my attorneys can do A, B, and C with my assets, but they can't go so far as to kick my spouse out of the condo and sell it and invest the money in a term deposit. Also, another option is to consider an inter vivos gift. If you anticipate or are concerned that there's going to be an issue at death, then while you're alive and you still have your faculties, make the gift now to the spouse, and then there's whatever you have gifted falls outside of the estate. There's not going to be a dispute at that point. It will fall also outside of the scope of the power of attorney that you may actually want to be in the hands of your daughters, whom you trust, who are younger and more able to deal with and cope with the issues they might have to deal with as your attorneys. And then again, back to the letter of wishes. In our case, the question was, and we ultimately settled it, did dad actually want to change the will or not? Okay, if in not changing the will, was dad acknowledging, yes, my daughters have driven me crazy, but I love them anyways, and I want them to continue to benefit under the will. Don't back down or don't hesitate to make your feelings known. In any event, you're not going to be around to see how people react to it. So it really just clarifies things for the family and helps avoid conflict. Over to you, Vivian, unless either someone has anything to add.
Thank you, Yoni. Example 4 is a common scenario I encounter in my practice in BC. So I'll jump in here. In this case, we have a father who lived in Vancouver for many years before he passed away. His son, a travel blogger, spends very little time in Vancouver, but stays connected with the family through FaceTime, Zoom, text messaging. The daughter, who was adopted by the father as an infant, owns a cafe on the same street where the dad lived. So because of the proximity, she was his primary caregiver after during the last 10 years of his life, driving him to his appointments after he stopped driving himself, visiting him several times a week to help him with chores, bring him food from her cafe. And given the time and effort the daughter devoted to caring for their father, the question really is, should he allocate a larger share of his estate to her rather than splitting it up 50-50 between the two siblings? There is no simple answer to this because in BC, we have something called wills variation, and it's not unique to BC, but it's something that's very prominent in the BC province. What this means is that a spouse or children, biological or adopted, can apply to court to vary the deceased will, provided that they can prove to the court that the will maker failed to meet his legal and or moral obligation to them. In many cases, there will be various adequate, just, and equitable ways to divide the deceased assets. The court should only interfere if the testator has chosen an option that falls below his or her legal obligation or moral obligation to the spouse or the child. I want to make sure that everyone is also aware it's not very clear in the legislation, but the testator's freedom to dispose of his or her property, what we call testamentary autonomy, should also be recognized. So for spouses, the court will consider the spouse entitlement in a notional separation immediately prior to the deceased death. Generally, this means that the surviving spouse is entitled presumptively to a 1/2 undivided interest in the deceased spouse family property, regardless of their respective uses or contributions. There may be circumstances where equal division, the 1/2 undivided interest, would be significantly unfair or inadequate for a spouse in a variation claim, prompting the court to consider moral obligations to either increase or decrease the amount given to the surviving spouse. Moral obligation can be affected by factors such as the length of the marriage or the marriage-like relationship, the care the surviving spouse provided to the deceased, and the difficult financial circumstances the surviving spouse may face, including their inability to improve their situation because of age, health, or injuries. For children, independent adult children, a testator generally does not have a legal obligation to them unless that child contributed to the estate. Courts have considered several factors that inform the existence and strength of the testator's moral obligations to independent adult children. The list is on the screen. It includes the nature and strength of the relationship between the testator and the claimant, the size of the estate, any contributions by the claimant, the reasonable health expectations of the claimant, the standard of living of the testator and the claimant. The list is really long, and I will not go through each factors by factor, but something to note is that these factors tend to overlap, and they are not approached in isolation as independent categories. In reality, the question is, what should you do if you want to prefer or exclude a child? The law requires you to have a valid and rational reason for your decision. You can document the reasons either in the will itself or in a separate document created at the same time. Often, as Yoni has mentioned, it's called a letter of wishes. I want to provide an example, a real life example of what type of reasons could be valid and rational. So in a 2013 Court of Appeal case in BC, the mother had 9 children, 6 from her first marriage and 3 from her second. Her estate was worth $70,000 approximately, and she allocated each of the 3 children from her second marriage a quarter share. And the remaining quarter share was divided among the 6 children from her first marriage. In her will, the mother stated that she wanted to do this, and she wished to give a significant greater share of her estate to the children from her second marriage at the expense of the children from her first marriage, because most of her wealth was acquired during her second marriage and from her second husband's assets. In evaluating the moral obligation, the court considered whether the deceased's reasons for this unequal distribution were valid and rational. The evidence presented at trial showed that the deceased's wealth was mostly acquired during her second marriage and from her second husband's assets. So accordingly, the court upheld her reasons for the unequal distribution made by the deceased in her will and dismissed the claim from the 6 children from the first marriage for a will's variation. Again, Yoni and Alex have already touched upon some of the second point. To consider using estate planning tools like trust, which can help ensure that assets move into the trust are not part of your estate and will not be subject to will's variation. And I will pass it on to Alex for more comments on this topic.
Thank you, Vivian. Carrying on with some potential solutions in the scenario where one child is to be preferred over others or excluded. I really in my practice do have careful conversations with clients when considering these kinds of topics, because what we see in our practice is that this kind of either preference or exclusion of children can lead to disputes, and I don't think that is the legacy that the testator intends to leave, is to have their family members fighting with one another. The reasons for the preference or the exclusion are often things that I find have been thought about perhaps only relatively superficially by the testator, and sometimes are things that if the testator spends some more time and care thinking about, they may be able to work through with a child that they are estranged from or in some dispute with, in the case of excluded children. And so in discussions with many clients, the concept of treating your children equally, regardless of their life circumstances, and the benefits of doing so, often seem to have not been thoroughly considered. And of course, we all have, if you have several children, then, there's some are going to be more successful than others. You may get along better with some and not with others. And as we've all seen in our practices, you may think that one of your children does not need the funds because they're independently successful. And those kinds of things can change. It may be that they're successful now, but fortunes can change. And treating your children equally, most parents, when discussed with them, will see that the wisdom of doing so. And this is a primary mechanism to avoid disputes down the road. Now, of course, there are circumstances where you truly are committed to not including a child in your estate because they have truly misbehaved. Perhaps even it may be dangerous to do so if they have addictions or other dependencies and that sort of thing. You can't give them the funds. And so these things happen in life, and there are circumstances where you cannot follow the rule of treating your children equally. But as a general statement, it is a mechanism to avoid disputes where you can. And then communicating about it is truly important so that your children have an expectation that even if they aren't doing as well or they're doing better than other children in the family, there will be an equal distribution rather than some unequal distribution. The other thing that I'd like to advise clients on is to consider the long-term consequences of excluding or preferring a child. These things can have a generational impact, and by that I mean, you think that you're doing something that's only going to affect your children, but in fact, the divisions that you create by excluding a child can last for some generations. And I have seen examples of this, particularly in farm families in Alberta, Saskatchewan, Manitoba, British Columbia, where one or another of the children is preferred in the sense of receiving the farm. And some generations later, the hard feelings that result from that preference will carry on. And I realize it's not an easy situation when you're trying to keep the farmland together, but it applies beyond just the farming scenario. You really can have damaging impact, not just on the current generation, but on multiple generations. And again, I don't think that's what the testator is typically anticipating. And so if there is truly a scenario where you must exclude a child, again, because of a dependency or addiction or what have you, or behavior that is simply truly unacceptable, it's typically my advice to clients to consider just skipping that child, but gifting over to their children, the testator's grandchildren, in the event that there are any or that there become grandchildren, so that you don't have that generational damaging impact, and you're not creating harm that is unintended. We'll move on now to example 5, which arises from some cases that I have seen involving testators who had children typically out of wedlock, and chose not to share the fact of the existence of those children with their children born into their original family. And so this is relatively rare. The other thing we see and have seen, again, relatively rare, is the situation of having second families, secret families, where some individuals actually have an entire other family that is the existence of which is not shared with their first family or original family. And this creates difficulties, of course, when often wills or trusts will use generic language to refer to my children. And sometimes the terminology used is my issue. And that, of course, captures all of the children or issue of the deceased, of the testator. And that can be problematic when you have these scenarios of children that are born out of wedlock that may not be or are not shared, the existence of which not shared with the other family members. And the testator may not have them in mind, or maybe they do have them in mind. And the point here is, from a planning standpoint, this can create, again, litigation and unintended damage to the relationships amongst your family members. And it may be that you are not prepared to share the existence of this other child or children with your family, but you have to take great care in your estate plan when you do have this scenario arise, so that you're being intentional in your wording and not unintendedly benefiting others or leaving them out as you may wish. So we have addressed some other potential pitfalls already, having to do with joint bank accounts, with powers of attorney. One other planning activity that is relatively common, perhaps very common these days, is establishing joint bank accounts with an elderly parent, putting property in joint title, and granting powers of attorney to your children. As Yoni's example described, this can lead to unintended outcomes. As time goes on, your children or child may not see things the same way as you do. They may be resentful of a relationship that you have entered into. They themselves can become resentful or financially unstable. They may develop themselves addictions. These days, you see a lot of gambling addiction or other addictions or financial dependencies that are unanticipated. They may go bankrupt. And you have to have these risks in mind. And so these types of planning activities, establishing joint accounts or putting property in joint title, can be useful. But I generally think they are better saved for very late stage planning rather than mid-stage planning, given the risks that are associated with them. We have had a number of questions come in, and so I will pass it over to my fellow speakers to see if they have been able to review some of those questions and deal with some of the responses. I do have a question and response that I can address as well.
Sure. I'll jump right in. I saw that there were quite a few questions concerning the cognitive assessment, whether it's a contemporaneous one, at the time that you're preparing your document, if it's a POA or a will. One of the questions is, how much does this cost? So my immediate answer to that is a lot less than a retrospective expertise. So the retrospective expertise being the expert who comes to court after the testator is dead, and in the context of litigation, tries to convince the judge that the testator either had the capacity or not. So the actual cost obviously depends upon the jurisdiction. Even within Quebec, it'll be more expensive in Montreal than in some of the cities outside. But in Quebec, it's not more than a couple of $1,000s to have done. And as I said, it's a lot cheaper than litigation and having an expert come and testify on the basis of the medical records without having met the deceased. And the other question concerning the cognitive assessments is who should be assessed, and is it necessary at all times to be assessed? Obviously not. Not everybody needs to be cognitively assessed to confirm their capacity. I would recommend, however, that if you were preparing a will, following or shortly after having or recovering from an illness, that would have seen you hospitalized for some time and taking medication, where someone might question whether or not you could have been influenced by your physical condition or the drugs or medication that you were taking. That would be you'd be a good candidate for an assessment. And another one is, of course, if you're advanced in age. You see people who are in their 80s and 90s who are perfect, and then you see others who have difficulties debating, like Joe Biden. And I'm not saying anything about his capacity, but if he were to prepare a will, I would advise him to have an assessment done so that there is no discussion or debate after the fact. I think that covered a few of the issues with respect to cognitive assessment. I don't know if Alex or Vivian, you want to take another question that you see?
I can take the next two questions. So the first question is a no context clause in a will enforceable? I don't know this top of my head, but I do recall reading case law that it can be disputed. And as far as in BC, there is case law citing the reasons and when a clause like this will not be enforceable in BC. And also to relate to give you some context, in BC, because we have the rules variation provision in our WESA, it might be considered void as contrary to public policy, because it would prohibit valid wills variation claim. The second question regarding whose morality governs, perhaps the testator's moral standard is different from the court. So the drafter, does a lawyer have to urge the anticipated court sense of morality? Again, this is related to the wills variation provision. And there is a new Court of Appeal case that says, in assessing the testator's moral obligation to adult children, that assessments must be made using the objective standards of the reasonable testator. So in addition to the subjective assessment of what the deceased was considering at the time, the court is also able to use the objective standard in considering whether a will should be varied. And perhaps I can pass the mic to Alex to answer the remaining questions or any other questions you wish to address.
Thank you, Vivian. Yes, so we've had a question asked in the Q&A about how can an adult child who is experiencing mental health challenges or addiction still receive their inheritance while safeguards are included for the funds? And that's an excellent question. It's a very difficult topic and depends on the circumstances, of course, but there is the ability to establish a trust that can be used to still provide support for a child who is suffering mental health or addiction issues. And in the old days, they were called spendthrift trusts. We don't use that terminology anymore, but there are mechanisms that can be used to provide still some support to those children who are experiencing those difficulties, and take into account the risk of providing that child with funds or unlimited access to funds. So the answer is that we can do that. It comes with, as with any trust, it comes with some practical impacts in terms of maintaining the trust and making filings, and some cost and other things associated with it. But in the right case, we absolutely can still see that the funds are preserved for the child undergoing those struggles. So I think we've come to the end of our time frame. Thank you all very much for attending, and thank you to my fellow speakers.
There are a number of questions and we cannot answer all of them, unfortunately. But just a reminder, the information for your Ontario, Quebec, and BC CPT certificate is available in the chat and on your screen. Fasken will be hosting the second webinar in our 2024 estate litigation series on October 24th. Please keep an eye on your inbox for the invitation. Thanks again for coming, and have a great morning or afternoon, everyone.